the Legal Corner podcast series. Welcome to today's episode of The Legal Corner, a podcast which covers a variety of legal issues to keep you informed. Hosted by attorney at law Colin Dinnoo and communications specialist Leonardo Torres.
Thank you for joining us for another episode of the Legal Corner podcast series. I am your host, Colin Dinnoo, attorney at law, and I am happy to be with you once again. My co-host, Mr. Leonardo Torres, is absent today because of work commitments. In fact, Leonardo's ability would be reduced for the remainder of the season, but I know he will join us when he is able to do so. In today's episode, we will be looking at the topic of property law in Trinidad and Tobago. By public demand, we decided to have an episode in which we will be able to deal with and ventilate issues surrounding the purchase of land in Trinidad and Tobago. Now, joining us today on the show to provide some perspective on this is Mr. Nestor Dinnoo-Alloy. Just to tell you a bit about him, Nestor Dinnoo-Alloy is a young man who has experienced many vicissitudes of life, but this did not stymie him from pursuing his dreams and aspirations. The latent effect of dealing with many of life's ordeals has caused him to have a passion for helping people. This is the paramount reason why Nestor Dinnoo-Alloy chose a career in law. Today, Nestor Dinnoo-Alloy is an attorney at law who runs a firm, Nestor Dinnoo-Alloy and Company, located at 18 to 20 Pembroke Street, Port of Spain. Prior to becoming an attorney at law, Nestor attended the University of the West Indies Cave Hill campus, where he attained a Bachelor of Laws degree with honors in the year 2015. He further went on to pursue a legal education certificate at the Hugh Wooden Law School, where he was awarded same in 2018. He is currently reading for a master's degree in law at the University of the West Indies, St. Augustine campus. Nestor practices in the following areas: conveyancing, probate, criminal law, corporate law, civil litigation, and family law. Apart from law, Nestor is fond of learning new languages. Hence, he is almost fluent in Spanish and is currently studying French. He also enjoys cooking, traveling, and meeting new people. So welcome to the Legal Corner today. Nestor, how are you?
I'm fine. And yourself?
Excellent. I'm even better now that I have this opportunity to speak with a distinguished individual such as yourself on this very interesting topic of property law in Trinidad and Tobago. So Nestor, we're going to jump right into it. I want you to tell us. Great, excellent. I want you to tell us what are the pieces of legislation that govern land transactions in Trinidad and Tobago.
Well, there are two main pieces of legislation that govern land transaction in Trinidad and Tobago. That is the Conveyancing and Law of Property Act and the Real Property Act, formerly called the Real Property Ordinance. And basically, it governs transaction that touches on concern land in terms of conveyancing, in terms of mortgaging. Basically, it deals with how land is transferred from person, or I would say entity. When I say person, I also mean entity as a company as well.
It would be safe to say that there are two regimes when it comes to land law in Trinidad and Tobago.
Yes, in Trinidad and Tobago, we have two types of systems, title systems. That is the registration of title system and the unregistered system, which many persons would say the common law system. Both touches on concern land. However, the method of showing title is different. With the registry, let's start with the unregistered system. With the unregistered system, although it says unregistered, your title or your document or the document that demonstrates title still has to go through some sort of registration, and that is at the Registrar General's office, which is which falls under the Ministry of Attorney General and Legal Affairs. And basically, that in order to demonstrate title, it is demonstrated via what is known as a deed. Many people are familiar with it. It's a legal size page document, and that will demonstrate title. Conversely, with the registration of title system, you have what is called a certificate of title that demonstrates proprietary interest in land. And the difference between the two, because one may argue why we have two, is it wouldn't that be a bit redundant and unnecessary? There are pros and cons with the two, and it is up to the individual to choose which method of registration of title they're going to pursue. I personally prefer the Real Property Act method, which is registration of title, where you are given a certificate of title. Under the unregistered system, one has to conduct searches in order to verify or to make sure that the title is good and marketable. If you're dealing with the sale of land, a prudent attorney would have to conduct some sort of title search in order to determine that that property that is up for sale is good and marketable and free from encumbrances, right? And when we say encumbrances, sometimes the land could be the subject of a mortgage. It could have a debt, a judgment debt against that is against the owner, and the judgment, the Debtors Creditors Act has a provision that says that any judgment that is against a person goes against their real property. So in other words, that property is encumbered because of a judgment, as long as that judgment is registered. So it just goes to show that it is important to conduct title searches under the unregistered system. On the other hand, when you're dealing with the registration of title system, there's no need to conduct a title search where someone physically go into the Registrar General's department and conduct searches, because under that system, that you have a certificate of title, which is a document that shows ownership. At the back of that document, you have what is called endorsements. So every transaction that concerns the subject property is endorsed at the back. So you have a lot of memorandum concerning a particular transaction that concerns the land. So if it is that the land is transferred to a person, you would see memorandum of transfer. If you're dealing with a joint tenancy, that is where you have two parties on the property, and it so happened, two parties who own that property, and one happens to pass away, and the survivor is contemplating selling that property. That remaining survivor or remaining joint tenant has to go and have the death of the deceased joint tenant endorsed at the back. So there's a lot of paperwork that has to be done in order to prove the person has died, right? And that person's death would be endorsed by the Registrar General at the back to ensure that there is no one else who would lay a claim against the potential buyer. Right? So if you're dealing with a mortgage, that you would see a memorandum of mortgage. If that mortgage is satisfied, you would see at the back a memorandum of release. So every transaction has some memorandum endorsed at the back of the certificate of title, which makes it easy to verify ownership.
Right. Now, in terms of the physical documents, because I know there are differences in terms of the structure of a deed as opposed to a certificate of title and so on. So just walk us through in terms of what would be some of the differences between both documents.
Well, I know in terms of the parties are referred, well, under the common law system, the unregistered system, you would see the terminology vendor purchaser. Under the registration of title system, you would see on a certificate of title the proprietor proprietor or proprietress and the purchaser. So there's a difference in the terminologies. With respect to a deed of conveyance, you would see the word deed of conveyance, as opposed to the registration of title system, you would see a memorandum of transfer.
But I like that point you made about the fact that there are endorsements at the back of the certificate of title, which would really itemize everything that would have happened to that piece of property. So there's that record then, whereby
Yes.
there's no need for a search because everything would
There's
have
no
been
need for a
itemized.
search. And one point of information, when you're dealing with a property that falls under the registration of title system, you have this concept in the feasibility of title. Put simply, it means title cannot be easily defeated. Now that shouldn't just be taken absolutely. There are exceptions to that rule, in that the doctrine of adverse possession can be one means through which a person can challenge your property, ownership in a property that falls under the registration of title system. Another way a person can challenge your title is fraud. And when we say fraud, it is not just regular fraud or just fraud in its general sense, right? There's a particular case, it's coming out of New Zealand. I believe it's Assets and Company, if my memory serves me right. But basically, in that case, they define the type of fraud that has the potential to defeat title. And I can't remember the law that said it, but the judge's name. But he was defining the type of fraud to be actual fraud. And when we say actual fraud, the person who is laying a claim against the defendant must prove that the defendant had the intention. So there's the element of intent to deprive, to cheat, to deceive someone deprive the person from the land, the ownership in the land. So if it is that the element of intention is in the equation, well, then that constitutes actual fraud. All right. There are cases where one would think fraud would be I have dealt with a case where the person forefathers would have committed the fraud. That in itself, in my opinion, I don't believe it constitutes actual fraud, and that case is actually the subject of an appeal. So I don't want to ventilate the facts too early, but basically, based on my readings, I understand that you cannot ascribe fraud to be that of acts done by your forefathers 4 generations back. It has to be you, the individual, but the claimant is imputing that you, the defendant, would have done an act that is calculated to deprive, deceive, cheat someone out of their rights to the land. So it's really much a challenge to defeat title under the registration of title system as opposed to the unregistered system.
Excellent. I like how you would have referenced that case to give us some legal and case law.
Are you with me?
That will really substantiate that point as it relates to the whole notion of actual fraud. Right? Now, I want us to talk a bit about the documents, because to close a land transaction, there are certain requirements, certain documents that would have been required by law to register a land transaction. So I want you to just walk us through that and tell us a bit about the documents that are required.
Okay. Well, firstly, you need the title document, which is the deed or the certificate of title. Right? That would help establish, it's a preliminary step to establish ownership, because there's a rule that is a Latin term, it's a long Latin term, but some people say nemodat for short, which says that a man cannot sell what he doesn't own. So therefore, it is very much important to ask the other party, the vendor, for the title instrument to establish his proprietary interest in the property that he purports to own, right? 2 forms of ID, and this is in keeping with FIU regulations, Financial Intelligence Unit regulations. This is a policy that was put in place in order to deal with land fraud and money laundering, and actually they're trying to counter the financing of terrorism. So that is a procedure that ought to be observed, and so 2 forms of ID is necessary. You need also to request WASA, up-to-date WASA bills and receipts to ensure that there are no charges on the land, because if it is you owing the state, that forms a charge on the land. You also need to request WASA clearance. If there's no connection, you need to request a WASA clearance certificate. Up-to-date electricity bill. If there's electricity on the land, there's a connection, you need to make sure that that is paid off. The attorney acting for the purchaser, would ensure that that is paid off. So you need to request a bill and a receipt showing that outstanding rates are paid off and settled, right? You also need to make sure that land and building tax rates are paid as well. There is a moratorium where land and building taxes have been suspended since 2009. So you need to request, make sure that you have your proof of payment up to 2009, right? I know there are talks I'm hearing talks about property taxes, resuming the collection of property taxes. So until then, you just simply have to ask for land and building taxes up to 2009. This is another requirement, but it's based on individual circumstances. If they are joint tenants, and if you read that title instrument and you see that there was a joint tenant, sometimes you may have to request a copy of the death certificate in the event that the vendor is saying that that person, the other party who's a joint tenant, is no longer on planet Earth. So the attorney acting for the purchaser should requisition or ask for a copy of that death certificate to verify whether or not that person is deceased. If it is after conducting searches and you see that there has been a mortgage the property is subject to a mortgage, sometimes not sometimes, but all the time you have to request, you have to ascertain whether or not that mortgage has been settled, right? And proof of that is by virtue of a deed of release and reconveyance, right? So it all boils down to the circumstances. Sometimes the property may be subject to a mortgage. Sometimes the property may have had a be subject to joint tenancy. So it's based on the circumstances. You will determine those other documentation, and all of this is just to ensure that the property is good and marketable. Basically, what that means is if it's free from encumbrances, and if that purchaser is to buy that property, he wouldn't have any problem. He wouldn't be the subject of litigation, and he can resell that property without any problems.
What happens in situations where persons I can think of more than one situation, so we deal with the first one first, where someone would say, you know what, I don't care whether that person have a good title or not. I like where that property is located, or I like that building spot for my business, and I want to go ahead and buy the property. What is normally done in cases such as those?
Well, a prudent attorney would not follow through with such a transaction. Well, I certainly am speaking for myself. If I have a client who is adamant, after knowing that there are encumbrances on that land, and he still wants to go through with the transaction, I tend to refrain from doing such, and I would advise him to find another attorney, because it took years for me to build my reputation, and I know it can be destroyed by one bad move. So I wouldn't advise a client to go through if it is that he knows or is aware that there are problems concerning the land. I certainly don't want my name on that instrument. Having drawn and prepared, this instrument was drawn and prepared. I certainly don't want my name there because one fails to realize that when that document is registered, that goes down on the record permanently.
Of course. Now, what advice you would give to persons out there who may say, I trust the vendor. It's somebody I went to school with, it's somebody in my neighborhood and so on. I don't need to do any searches, right? We will just make our arrangements and I will pay him in cash or kind. We will come up with some type of agreement where I can pay him and then I will get the land or I will get the house, as the case might be. What advice you would give to persons who may be thinking about
Well, I would say that's not a wise I would say method in conducting a sale for land. Reason being is that, well, if I'm acting for the purchaser, I would advise him to do it the proper way. First of all, land that has a value that is, 6 figures and up, or not even 6 figures. Once it is valued, it has a significant value to the land. I strongly encourage my client, and I also inform the vendor, right, that we will be paying via certified check, right? It protects both parties in case the purchaser is trying to scam the vendor, because once the vendor puts his name on that document and it's registered, the title has been transferred, right? So I would advise that a certified check be the form of payment to protect not only the vendor, but my client, the purchaser, because it creates some form of paper trail. So in the event that we are suing on the agreement for sale, right? That would be piece of the evidence to show that money was conveyed from one party to the other in the form of a check, and that is the proof. Now, there are some instances where there may be certain concerns. None seems to be coming to mind, but I've heard attorneys, they tend to use what is called an exoneration clause. Basically where the attorney is exempting himself from liability in the event that the land is subject to litigation in the future. That attorney is trying to clear his name by using that exoneration clause. I've heard about it. I've seen it. I tend to do a clean job when I act on behalf of my clients. So I don't rely heavily on an exoneration clause per se. I make sure and do my due diligence that is in the best interest of my client. Once you do your due diligence as an attorney, and even your client as well would have done his due diligence as well, physical inspection of the land to be aware of any patent defects, and you would have conducted your search in the Registrar General's department, and it would have appeared that everything seems to be okay with the land, and you pursue and purchase the land. If anyone comes in the future, right, and challenges your client or the purchaser and stating that he ought not have gotten that land, right, that purchaser may be afforded protection under equity. Equity would deem that person to be the chancellor's darling, or the bona fide purchaser for value without notice, right? So the courts of equity would protect that person. In other words, they get to keep the land so long that the purchaser would have conducted himself in such a way to put himself in a position to know whether or not there were any problems that touch and concern that land. And if at the point in time that was done and nothing surfaced, well then, under equity, that person would still be entitled to the land. So, all in all, it is very much important for an attorney acting for a purchaser to conduct a thorough search, title search on the property.
It's definitely necessary. Thank you so much for that. Now, at this point in time, we'll be taking a quick break, and we'll be right back. Thank you for staying with us, and welcome back. So, Nestor, before the break, you were giving us some good information as it relates to the whole aspect of, ensuring that attorneys do their due diligence and proper searches are conducted and all those different things like that. And that leads nicely into my next question as it relates to land fraud. How prevalent would you say that land fraud is in Trinidad and Tobago?
Land fraud is very prevalent in Trinidad and Tobago, and I don't believe that the governments, be it present and past, has done enough work in trying to stamp out land fraud. The way the system is designed, particularly, I would say the unregistered, the common law system, I think it is designed in such a way which perpetuates land fraud in this country. As an attorney, I have dealt with situations where clients would have lost their property because persons would have drafted their own deed and gotten it registered, and it's on the register, and only for that person to learn, by the way, that the property has another owner, right? And I think the reason for this is because it is easy to get documents on the registry, and I believe they need to look into that. I've seen it on many occasions. I've seen it even with the issue. I'm a criminal attorney as well, and I deal with a lot of bail matters, and I learned that there are certain persons engaging in bail who would have observed land that has not been occupied for a number of years, and they know that it was owned by a particular person, and that person never had children, and no one never came forward to lay claim to the land, and they would have created a deed and gotten it registered, and now they are representing themselves as the owner, right? That's not the correct approach, but they managed to have a deed, and now they're using that document as a means to secure a bail. So the system, I say, is designed in such a way which encourages fraud, and the authorities need to look into it.
That is eye-opening that someone would be able to do something like that, where they can make up their own deed and give themselves title based on the situation. Because there are many such scenarios where persons may have migrated and they left their property here and so on, and people can just take it upon themselves based on what you're saying, and it is so unacceptable that stuff like that is being registered without any type of checks being done. But you tell us, how can persons protect themselves from land fraud?
Back to the point that we were discussing prior, conducting proper search. That is one of the many ways that you can ascertain whether or not the vendor really and truly owns the property. It is from conducting a search you will see who owned the property prior to the vendor holding the interest, and you are able to establish what we say in law, a chain of title. And if there, which is basically it's just a chronology of you looking at the chronology of events that led to the person, the vendor, having that title presently. And if there are any gaps or breaks in that chain, you, the prudent attorney, ought to ascertain the reason for the gap and try to fill in those gaps by asking or requisitioning certain documentation. And if that cannot be satisfied, you ought to advise your client, the potential purchaser, to not follow through with the transaction. And one thing I forgot to mention, as a preliminary step to buying land, you ought to enter an agreement for sale. Reason being is that it establishes the intention to create legal relations. Apart from that, it allows the purchaser to do his due diligence, or the attorney really to do his due diligence and do a background check on the land and ask questions. And you have a 90-day period to do such, which is the standard practice. I mean, you can contract outside of that 90-day period, but the standard practice is 90 days. You have to do all your scrutinization. You're scrutinizing the land and asking any question, asking the attorney on the other side or the vendor on the other side, any question that may be of concern to you. Right? So that is one way, conducting proper title. Another way I would say is to bring your land under the Real Property Act, formerly called Real Property Ordinance, because back to the concept we were discussing before, in the feasibility of title, your title wouldn't be challenged easily, so people can't really commit fraud so easily under that system, as they would have to have the certificate of title. There's only one certificate of title that is issued to a purchaser. If it is lost, you'll have to make an application to have a duplicate copy or replacement, right? As opposed to the unregistered system, you can request multiple certificates, not certificates of title, but certified copies of the deed of conveyance, right? So that's why it's a bit challenging to commit fraud under the Real Property Act, land that falls under the Real Property Act. That's why I would advise persons better to bring your lands under that act. So it will be very difficult for people to challenge your title or commit fraud with your land.
Yes, definitely. And as said, this has been a great discussion. I believe that is an excellent point to bring the curtain down on today's episode. So I would like to sincerely thank you for sharing from your wealth of knowledge, for taking the time out from your busy schedule to be with us today. It was greatly appreciated, and I know that the audience will tremendously benefit from what you have to say.
And with that being said, I too would like to express my gratitude for having me on this program. I deem it an honor and a privilege to be here. Anytime I have an opportunity to share knowledge, information, I try to step up to the occasion. So thank you for having me, Colin, and I do hope that I could be a part of this program in the future. I'm as long as I have the free time to do such. But I thoroughly enjoyed it, I must say.
Excellent. Exactly. Glad to have you, Nestor. Now, this has brought us to the end of another episode of the Legal Corner podcast series. I'd like to remind you to check us out on social media. On Facebook, we are the Legal Corner podcast series. On Instagram, we are at the Legal Corner podcast. We are also on Patreon if you are interested in supporting our work. If you enjoyed the show, I would like to ask you to share it with your friends and family. Feel free to leave us a rating and a review on Apple Podcasts or Podchaser. We'd also love it if you subscribe to our podcast so you won't miss any of our future episodes. Special thanks to the members of our promotional team who are helping us to get our message out. Bye for now, and God bless.
Thank you for listening to the Legal Corner podcast series. For more information, please visit us at our Facebook or Instagram pages or send your comments to thelegalcornerpodcast@gmail.com. We look forward to hearing from you.